Thank you, General Holder. We'll begin the questioning, and I'll start with this. The Department of Justice is charged with providing legal advice to make sure the President and executive agencies operate within the bounds of the law and the Constitution. Of course, it's not just the Justice Department. It involves advice regarding our nation's health care laws, education laws, immigration laws, welfare laws. Doesn't the Take Care Clause require the President to enforce the law even if he doesn't like the law in question?
Well, the President has a constitutional responsibility to enforce the laws. That is clear. The Justice Department has an equal responsibility to defend statutes that Congress passes, unless the determination is made, and it happens very infrequently within the Justice Department, that there is no basis to defend a statute. Such an event happened with regard to the Defense of Marriage Act and the ability that we had in a unique circumstance in the Second Circuit to make a determination that a heightened scrutiny standard should apply to the constitutional determination of that statute. And on that basis, we made the decision not to defend the statute, a decision that was ultimately upheld by the Supreme Court.
I am concerned about some of the decisions, some of the directives that have been issued by you and others in the Department of Justice. Is it your view that there is any limit to the President's prosecutorial discretion?
Well, I mean, the discretion must always be exercised in a responsible and constitutional way. There is a vast amount of discretion, I think, that a President has, and more specifically that an Attorney General has, but that discretion has to be used in an appropriate way so that you're acting consistent with the aims of the statute, but at the same time making sure that you are acting in a way that's consistent with our values, consistent with the Constitution, and protecting the American people.
Could the President conceivably decide that with regard to a particular law that the discretion is to not enforce that law at all, even though the law is on the books?
Well, I mean, to not enforce at all, you know, that's a categorical statement, and in a hypothetical circumstance, it's a difficult question to answer. The determination, as I was referring to before, not to defend the constitutionality of the Defense of Marriage Act might fall into the category that you have described, but it is one, as I said, that was very controversial at the time we announced it, but ultimately was upheld by the Supreme Court.
Currently, under the modified Section 215 order with regard to foreign intelligence surveillance, the government is no longer determining whether there is reasonable articulable suspicion, or what's called RAS. That the target pertains to foreign terrorism. Those determinations are now being made by the FISC, the Foreign Intelligence Surveillance Court. How is that structure being implemented under the modified order, and how is the FISA court approving the queries of the data under the modified order?
Well, I think that we're doing so pursuant to the orders of the President, which I think are entirely reasonable, doesn't have an impact on our ability to make very good use of that tool. We go to the court, present the case that we make using that reasonable articulable suspicion standard. The court then authorizes the action that we seek. We now limit the action that we take to 2 hops as opposed to 3 hops. And I think that the way in which we are now proceeding is, again, consistent with the President's direction, but also is consistent with our obligation to keep the American people safe. It has not had a negative impact on our ability to make use of that tool.
And how is the court, the FISA court, approving those queries of the data under this modified order?
Well, the court is presented with a request, a statement of a statement by the department that we feel that reasonable articulable suspicion has been met. They make a determination about whether they agree or disagree, and the order is then signed.
Moving to another subject, and that is this question about the application for grants. The Office on Violence Against Women, which is within the Department of Justice's purview, recently announced changes to its grant solicitation process for fiscal year 2014, which limits the universe of grant applicants prior to grant recipients for a number of the office's discretionary and competitive grant programs. Specifically, it's limiting under 6 of those programs to only applicants who have been prior recipients. This concerns me greatly, both from the standpoint of the appearance of favoritism and from the standpoint of not looking for new and innovative ways to combat violence against women. I wonder if you would comment on why this policy has been permitted to take hold.
I'm sorry.
I just giving you an opportunity to respond to that.
Our grant making is really headed by our Office of Justice Programs. The woman's name is Carol Mason, in whom I have total faith. What we have tried to do under her and her predecessor, Lori Robinson, is to seek out from a variety of places grant proposals, support those proposals that we think are of potential benefit, and then actually do something I don't think has necessarily been done before. Used evidence-based means to determine the effectiveness of those programs, and on that basis, make further determinations about funding. I'm not aware of any determinations that are made to exclude from grant making or grant seeking institutions that on any basis, we take into account those grant applications that are made, use neutral criteria to determine whether or not they should be supported, but then, as I said, look after what happens after the grant is made to see the actions that are taken, and again, on an evidence-based basis, decide whether or not the program should be supported or attempted to be replicated in other parts of the country.
Well, the information I have is to the contrary. My time's expired, so if you will, I would like to pursue that matter with you after this hearing, and we'll get you some specific questions and concerns we have. But I am concerned that new applicants are being excluded and that current applicants are being renewed not in a competitive environment, and that concerns
Mr. Chairman, I will say that I don't think that is the practice, but to the extent that your concern is a legitimate one, that is something that I will look at, and I will get back to you. That is not the way I understand that we are proceeding. But if I'm wrong, we will get back to you, and that practice will be corrected.
Thank you.